All right, welcome to a Colorado exam prep. Today we're going to talk about approved forms, agency law, and contracts. All right, so we're going to dive into these components of your Colorado state portion of your exam. And let's kick it off here. Let's kick it off with Conway-Bogue. This is where it all started, everyone. So when we look at this thing, we got Conway-Bogue, 1957. All right. So, firstly, the question was this: it was like, should real estate brokers be prohibited from preparing legal documents, right? Contracts, deeds, leases, and should they stop giving advice about legal effect of a contract, right? Like, this is where this thing all started, right? We're going to be called what's an associate broker in the state of Colorado. And through that associate broker, you guys will hold the highest licensure in the United States. And what happened was these lawyers popped up, right? We got the Denver Bar Association here. And they said, hold on, these real estate agents are going through and they're creating contracts to help buyers and sellers, and they didn't even go through law school. And they're like, this is pretty ridiculous. And like, that was the whole case for this. So that's Conway-Bogue. And so the ruling came out, right? The Colorado Supreme Court said, listen, we're going to allow it. We're going to allow it to continue to happen because we do not want to disrupt what has been working for so long. And so this is what they said, though. They said, but you know what? You're absolutely right. Let's go through and let's put some ground rules in place. All right. So we need some ground rules in place to make sure that these agents truly know what they're doing because we know that the law, real estate law, was put in place to protect the public. And so they said, listen, what we're going to do is we're going to allow them to prepare certain legal documents. And we know this. And on top of that, we're only going to allow them to give advice on real estate transactions that they are handling. All right. So we know that if we're not a part of the contract, right, if we don't have an agency agreement, if we are not in the employ of either a buyer, a seller, a landlord, or a tenant, that would be the illegal practice of law. All right. If we are not a part of the transaction in an employment type agreement, that would be the illegal practice of law. And they said, listen, and as long as the real estate agent doesn't charge for preparing documents or give legal advice outside of their scope and purview, we have no problem with it. All right. So then we got this thing called Rule F, Commission Rule F. And so when we're talking about Conway-Bogue, one of the things that they put in place when we were talking about preparing legal documents is that they said, well, listen, we need to have commission approved forms. And inside these commission approved forms, right, these are contracts, disclosures, agreements related to real estate. They said, listen, we're going to send these guys to real estate school now. And inside real estate school, we're going to teach them the basics. And then when they become licensed real estate agents, these are the forms that we, the Colorado Real Estate Commission, have approved for them to use in their scope of work, helping buyers, sellers, tenants, and landlords through the real estate process. So we have commission approved forms. And those commission approved forms are known as standard forms. All right. These are standard forms, which means like if we're doing buying, selling, or tenant placement, these forms, for the most part, 99.9% of the time, they're going to work for the transaction. All right. Like these are the forms that when they are done, they're going to pretty much apply for everything. So inside of Rule F, it ensures that we're following the Conway-Bogue decision for preparing certain legal documents with commission approved forms, the standard forms, and it's going to promote the uniformity and the public protections. Because keep in mind, the law, the Colorado Real Estate Commission's job is to protect the public. So let's go in here and let's talk about agents real quick. So we're looking at real estate agents. And the first one, we got a special agent. This is a one-time task, maybe just one transaction. And we look at this thing, and for the seller, it's to find them a buyer who is ready, willing, and able. We know that's how we get paid. We find a ready, willing, and able buyer. And for the buy side of things, we're going to find the one property that meets their needs. All right. Like, guys, that is a special agent. A special agent, it's one-time task. It's probably what you saw on HGTV or Selling Sunset or insert one of the many shows that's out there. And you are helping someone with the largest financial decision that most Americans will make in their lifetime. Help the seller find a buyer, help the buyer find a home. This is pretty much every typical home sale. All right. So, special agent, I just want you to think of a regular real estate agent that you've seen on TV helping someone buy, sell, or invest in real estate. But then we have this thing called a general agent. A general agent has ongoing duties. All right. Ongoing duties. And I think of a property manager. This is property management in my eyes. They're collecting rent. They might be having the maintenance crew go out. They're authorizing repairs. They have a full on scope of services that are ongoing. So we have a special agent. We have a general agent. And I do want to talk about transaction broker while we're in here. All right. We're going to talk about this a little bit more as we progress through the slides. Yet, I think it's very important when we're talking about the Colorado real estate exam that we understand a transaction broker. First and foremost, this is your default role in Colorado. And what this means is this. If you do not have a signed agency agreement, which would be your exclusive right, because in Colorado, that's all we deal with is the exclusive right. If you do not have an exclusive right agency agreement in place, your default is transaction broker, which means that you have no fiduciary duty. You are pretty much tour guide Barbie. You're Switzerland. You're a referee. You work for the transaction. You are trying to get the transaction to the finish line without offering any advice, without championing anybody. You are going through and you are pushing paper from the start to the finish line. And with this, you could assist both parties. And while assisting both parties, you're not representing either one. You are a neutral facilitator. And guys, again, this is your default, right? Unless you have a written agency agreement in the state of Colorado, your default is transaction broker. So let's talk about these agreements. And when we're talking about this, what I want everyone to keep in mind is the exam, for the most part, unless it puts you in another scenario, you're going to come from this from the perspective of a listing agent. You're going to come from this from a perspective of a listing agent, right? Because when we think about this, the buy side, the buyer's agent is a fairly new role in our industry. And we had this thing called sub-agency back in the day where really the seller had an agent and then the buyer would use an agent that actually worked for the agent. And that was a sub-agent. So on your exam, I really want you to frame it from the perspective of the sell side, unless they put you in a different position. All right. So when we're talking about the right to sell agreements, right? We're talking about Colorado. Firstly, this is an employment agreement. This agreement is between the owner and the broker, right? The principal and the broker, the client and the broker. These can be written, or could be an oral listing agreement. And so when I think about an oral listing agreement, firstly, I find that nuts when we're talking about a seller, because who's in their right mind is going to put a sign in the yard and say, hey, this person is open to selling their house and not have an agency agreement in place, like you're not going to be able to protect your compensation at that point. But yet, an oral listing is valid, but you can't be an agent, right? So that's the thing. Like, this is where people get tripped up, right? When we look at this thing, if you have an oral listing, your default transaction broker. You cannot have an agency agreement in the state of Colorado without it being written. So that's the first thing I want you to take away from this. Transaction broker, sure, absolutely. You can be a transaction broker and have an oral agreement in place. You cannot be an agent, a fiduciary, give advice without having a written agreement in place. What we also need to know is this: there's termination requirements in our agency agreements. There has to be a definite termination date, right? We know, here's a couple things, right? Firstly, the way that most agreements are going to conclude is through performance, right? You did your job. You helped the seller sell their home, performance. You helped the buyer find a home, performance. But yet, there's going to be some transactions that they don't get across the finish line. And inside of your agency agreement, you are going to have a definite, this is when I'm starting to work for you, and this is the day that our agreement comes to conclusion. And we know in the state of Colorado that that can be 1 year's worth of time. It doesn't have to be, right? It's all negotiable. Everything in every contract that we touch is negotiable. But yet we do know that the longest amount of time that we actually can have one of these agreements in place is 1 year. And I do want you guys to remember, no contract equals no pay, because guess what? It's not legally enforceable. You must have a signed listing agreement to claim the commission. The law doesn't support claims of volunteers, right? At the end of the day, if you do not have an agency agreement, you could be working for free because it's not legally enforceable. We understand this. No contract, no compensation. Introducing the buyer is simply not enough. So let's look at this holdover period. All right. So we have this holdover clause. These are in our agency agreements. And the agency agreement says, hey, if I find you a buyer during our work relationship through our agency agreement, my employment agreement to you, you will pay me. And there's this clause. And this clause says, what if we hit our termination date and the buyer that I had already negotiated with and handed that name to the seller, who I am no longer working with, what happens if they put a deal together? Well, you have this mechanism. And in this mechanism, this holdover clause, you establish a time frame or not, right? You don't have to have one. 30 days, 60 days, 90 days. And when you're going through, you say, Mr. and Mrs. Seller, if you go under contract after our agreement ends with anybody that I handed you a written name and I negotiated with them, you owe me my compensation. So it's negotiated with the buyer and submitted the buyer's name in writing to the seller. Now, here's the thing. If the seller signs a new listing agreement with another broker, all cards are off the table. All right. So that's one of the things that we need to keep in mind. If the seller is now working with a new agent, you will no longer have a claim to compensation. Because how do you prove that you are the procuring cause at that point? So let's talk about these two different contracts, right? Let's talk about the exclusive right to sell and the exclusive right to buy. So the exclusive right to sell, right? This is your exclusive right to sell the property. You are not competing with any other agents in your brokerage. You're not competing with any other agents outside of your brokerage. It is solely you, the designated agent. This agency does not extend to your managing broker. This agency does not extend to your supervisor if they're different from your managing broker. This relationship does not extend to anybody else in your brokerage whatsoever. You, the broker, have the exclusive right to sell this property. And guess what? This agreement, which is the only agreement that we have in the state of Colorado, guarantees that you earn a commission no matter who finds the buyer. Even if it's the seller's next door neighbor, family member, insert whoever here, you still get paid with this agreement. You do not need to be the procuring cause. The most protections for the agent, that is this contract right here. And this agreement, well, this is approved for both agency and transaction brokerage roles inside of the state of Colorado. There's a checkbox at the very top, literally one of the first things after we dated. It says, am I working as an agent or as a transaction broker? And guys, we're going to encourage everyone to get this thing filled out, right? Like, this is big. This is how you protect your compensation. You are not the March of Dimes. This is not a volunteer project for you. We're going to get this paperwork signed. But let's look at the buyer side of things. Well, the buyer signs this contract. Now they're hiring a broker. And they're hiring the broker to what? To find them a property to either buy and or lease. Because keep in mind on the exam, this is what we want to think about. Seller and landlord will be used interchangeably. At the end of the day, they're the same thing. Also, buyer and tenant are pretty interchangeable as well. All right. So we have to just keep in mind, like, those are pretty much the dividing lines. We have the seller and the landlord over here, and we have the buyer and the tenant over here. The buyer is the client. They're the employer. All right. Remember, both of these are employment agreements. And then we go through and the broker gets paid by. Well, here's the thing. The ultimate responsibility of pay is from your client. Now, with that being said, historically speaking, we have seen the seller pay buyers compensation through what's called a co-op. Yet, with that being said, your client is ultimately responsible. They may say, hey, I want you to try to go get paid from the seller, but they're ultimately responsible for paying you. Now, one of the things that we need to make sure of, right, is we're talking about holdover agreements and maybe even sign crossing rules, that we want to make sure that we're protecting our clients and that they don't have any agency agreement with anybody else. And we want to make sure that we're going through, and there's actually a section in our contract that goes through this, but yet we want to make sure that, hey, Mr. and Mrs. Buyer, you're not working with any other agents, are you? Because firstly, you could be breaching of a contract. There could be a procuring cause dispute. And if there's a procuring cause dispute, your client may be responsible for paying 2 commissions. If they're the seller, maybe even 3. Right? So when we're thinking about this, let's be very, very mindful as we're thinking about going through this conversation with our clients. And this is one of the things that we need to make sure that we're asking them, because when we're talking about procuring cause, at least on the exam, that the seller and or buyer is on the hook for compensation. And that's why we need to make sure that they do not have an agency agreement with anybody else. And guys, here we go. Check this out, right? Like, this comes straight off of the agency agreement. This is a binding contract. This form has important and legal consequences, and the parties should consult legal and or tax counsel before signing. So firstly, we know this. Guys, this is so important. Firstly, I know you're going to be tested on it. Secondly, it's on the top and the bottom of our contracts. This is the reminder. Hey, tax, legal counsel, a lot of this is going to be outside of my scope. Please go and have those conversations. Also, compensation charged by brokerage firm is not by law. All right. Compensation is completely negotiable. And guys, we just know this, right? Different brokerage relationships are available, right? Buyer agency, seller agency, transaction brokerage. They're all available. And we need to make sure that people understand what those look like. But let's talk about this real quick. You're a single agent, right? You are representing one client. And this is how this thing shows up to me, right? Let's say you represent the seller. All right. So you represent the seller. You are the seller's agent. You are selling 123 Main Street. All right. It's on the market. It's on the MLS. It's all over Zillow. You have done a great job advertising this property. Now, you now pick up a buyer. Doesn't matter where the buyer comes from, but you now have a buyer under agency agreement, which is perfectly legal. That's actually in your exclusive right that you are allowed to work with multiple clients at once. Mr. and Mrs. Seller, just because I work with you does not mean that I don't have other clients on other deals. And the stars align. And your buyer wants to write an offer on your seller's home. Well, hold the phone, right? We're like, well, that sounds like dual agency to me. Well, and you're right. That would be dual agency. If I represent the seller as an agent and I represent the buyer as an agent, that would absolutely be dual agency. And we know in Colorado that is absolutely illegal. Dual agency is absolutely not legal in Colorado. So, how can I assist both sides? Well, I would do that through a transaction brokerage relationship. And this could be framed as called double ending. They may frame this on your exam as called double ending the deal, double ending the transaction, where you're getting both the sell side and the buy side in the same transaction. It's called double ending. And so, one of the things that we have to do, because we're in an agency agreement with both, well, we have to get out this commission approved form. And it's called the change of status form. And what this does is it changes my agency relationship with the seller down to a transaction broker. It changes my agency relationship with the buyer down to a transaction broker. It's only for this one deal. So if this deal doesn't reach the finish line, I go back up to agency automatically. All right. So when we're looking at this thing, commission approved change of status form, it's letting our client know that they are no longer being represented in an agency. And here's the thing, guys. If you look over at this as how the form is handled side, it's already in your agency agreement. There's actually a provision that says that you have the right to do this unless they check a box. So by default, you are allowed to do this. There's a disclaimer, hey, I work with multiple people. And there's a disclaimer that says there might arise an opportunity where I have the buyer for your home. And at that point, we would be doing a change of status. Only if you check the box can you only represent them as an agent. So when must this form be delivered? Well, it's when the relationship's changing, right? Like when the things are happening, but it cannot be any later than when the contract to buy and sell is signed. Because if I represented the seller and I represented the buyer both in an agency relationship, and then I go through and from there, after going through and getting to the contract to buy and sell side of things, well, then I do have dual agency. So at the time the change occurs and or prior to the contract to buy and sell being signed, right? Because the contract's to that person, buyer, seller. That's when this form needs to be signed. Listing contracts, right? We already talked about it's already pre-baked in. And this is required. And this is what this form does. And you guys can see it, right? It actually talks about the property, talks about the seller, the buyer. It says what we had with them, when it was dated. We check all those things. We sign it. Parties sign it. We move forward. But you know what? I said on this next slide, you know what would be important? Let's get a better visual of this. So this is what I want you guys to understand because I actually think that there could be a test question around this. So we got party one, party two. Doesn't matter who's who. This is what you're allowed to do. You're allowed to represent someone as a client and treat the other party as a customer. Perfectly legal. Broker only owes fiduciary duties to the client. How else can I show up for someone? Well, I can show up for someone, transaction broker one, transaction broker two, perfectly legal. I'm assisting both in neutrality, no fiduciary duty to either party, referee, paper pusher. All right. These are the two different ways that you can show up for someone. Now, let's go back up to that first one real quick, client customer, because we need to keep in mind, like, what do we owe a customer? Well, the biggest thing is we got to treat them fairly. We must disclose to them, and we have to have some kind of reasonable care. And reasonable care gets a little weird because reasonable care just means like I'm allowed to help enough to not hurt my client. That's what reasonable care is. So, in all reality, where my head mostly goes is I owe them honesty and disclosure. So, where does a customer show up? Well, a customer could show up as you're listing a house, you're at your open house, unrepresented buyer walks in off the street, unrepresented buyer wants to put an offer in on your home. You represent your seller as a client, buyer as a customer. The other way this could show up on your exam and in real life, you represent either party. It could be buyer or seller. Let's just stick with seller. You represent the seller as an agent. They are your client. You are under contract. The buyer, you're going to treat as your customer, even though they're represented by another agent, they are still your customer. Again, you can't lie to them and you owe them disclosure. All right. So that's the two different ways that a client customer relationship could show up on your exam. What we cannot do, we cannot represent two clients. That's not allowed in Colorado. That's called dual agency. If you do get a dual agency question on your state exam, it is illegal. I don't care what the other answers are. You find that one out, you circle it, you move forward. The other way we cannot show up for people is client one, transaction broker two. You can't, right? So we're saying that we're going to assist someone with agency duties outside of the higher part of cold AC or old car, depending on which acronym you like. And the other party, we're going to give them all of the fiduciary duties. So we can't show up this way. What we would have to do is drop our client down to a TB. All right. And we go TB both. We understand TB both, perfectly legal. Can't show up for two people as a client. Can't show up for one person as a client, the other person as a transaction broker. It just doesn't work that way. Now, let's talk about commission approved forms. Conway-Bogue, Rule F. So, Colorado, guys, we're lucky in the sense to where they said, hey, guys, this is everything that you're going to need. And if you guys ever look through any of these, and you will, right, once you become a licensed real estate agent in the state, is that when we're looking at this, it has everything. It is a giant CYA. Pretty much any way that a real estate agent has been sued is pretty much in these forms to protect them going forward and to protect the public. And so we're looking at this. This is a standardized form for listing and contracts, disclosures, clear rules for handling clients. All right, this is all laid out. So in your listing forms, right, your agency agreements, it addresses your brokerage relationship, right? It says when you get through the top part of that agency agreement, it says everything that you are going to do for your client, because we know in the state of Colorado that we can't piecemeal it. We can't say, I'll do this one, and this one. That's against the law. We have uniformed duties as a transaction broker. And if they want us to be their agent, they get some extra stuff, right? Because now we're a fiduciary. We also know there's a seller's property disclosure. Seller's property disclosure can be used for residential, vacant land, farm and ranch. What it does is says, hey, buyer, this is what I, the seller, actually know about my property. That's your seller's property disclosure. All right. So your seller's property disclosure is it's going through and it's saying, these are the actual things that I, the seller, know about my property. Not what I think, what I actually know. If I'm looking at my wall and I don't know what's behind it, I'm not guessing. But if the roof leaks when it rains, I'm absolutely going to disclose that. Now, here's the thing. I want you all to know this for your exam. This disclosure form is optional. Your seller does not need to provide the seller's property disclosure. With that being said, in writing, they still must disclose any defects. So this doesn't get them off the hook. They don't get to say, well, hey, I never lived in this property, or I was of the landlord and this was an investment property. Well, guess what? Here's the thing, because we ran into this. This is actually very real. Practical application. The whole reason why this thing became optional but did not relieve sellers from their obligations to disclose was because we did have investors and they would say, I never lived in the house. I know nothing about the house. And you would say, but who paid all the bills when either the plumbing backed up or the refrigerator went out? The tenant didn't pay for that. The property management company didn't pay for that. You, the seller, paid for that. So you absolutely do know you must disclose. You don't need to do the paperwork. You don't need to do the official properties, the seller's property disclosure, but you must disclose in writing anything that you actually know, current knowledge. And then we know that we have to handle the money appropriately, right? We have to account for all money that doesn't belong to us. OPM, other people's money. Well, if they entrusted it to us, we have to be good stewards of their money. We have to account for all funds that are received, whether it's earnest money, security deposits, whatever that may look like. We are 100% responsible for that money once it is given to us. We also know this, we have to use a trust account. And that trust account has to be clearly labeled, right? This is a trust account for so-and-so's money. Guys, this is what a trust account is. For anyone that's like, why is a trust account a big deal? Well, a trust account says this. Let's say, unfortunately, you get sued. All right. Unfortunately, you get sued. And through this lawsuit, this judgment that comes against you, they're going to take some money from you, a good amount of money. And they see this bank account that you own. Well, the trust account says, no, you're being trusted to hold this money. This money is not your money. That's why the trust account's important. The trust account lays out that it's actually not your money. You're the steward of this money for somebody else. And so if a judgment were to rain down on you, that money cannot disappear because it's someone else's money. And we know that we can't have our money or the business money inside of this trust account. Now, there's an asterisk by this. And that asterisk is this. Let's say that account has a minimum in order to keep it open. All right, so there is a bank minimum on this property to keep this account open instead of closing. Where I think about this is property management. All right, so we got this account where most of the money coming in is going to go right back out to the landlord. Well, the landlord's not going to keep the money in that bank account. They're going to probably do something with it. Now, if the amount of money that comes out of that account takes it down to a threshold where the bank is not comfortable keeping that account open because there's $0 in it, the agent can put money in there. Now, it has to be in the agreement, right? It has to be in your agency agreement with the landlord that X amount of dollars is the agent's money that is being kept in this trust account for the sole purpose of keeping the account active so the bank won't close it. Now let's look at some closing instructions. This is the actual closing instructions you guys are looking at right now. This is Colorado real estate approved form. You can see that this form has important legal consequences, and the parties should consult legal and tax counsel. And it says the pre-printed portions of this form have been approved by the Colorado Real Estate Commission, except for the stuff that looks different. We know this, Conway-Bogue and Rule F. So what is the commission approved closing instructions? Well, firstly, what we know is they have to go with every single transaction. Every single transaction that we do has to have closed instructions, because guess what? This is the playground rules. This tells the buyer and the seller and the closing entity, whomever the closing entity is, the playground rules to close this transaction. It's going to say who the closing agent is, who pays for the closing services. It's going to start when the listing is signed. Now, here's the thing. The division recognizes that sometimes this might not get signed right away, but it needs to be signed before the closing happens. All right? They strongly suggest, they strongly advise that this form gets signed at the time of the contract to buy and sell, but yet we know life gets busy and messy and things happen. So it needs to be fully completed and signed once the contract is accepted, is the rules. But yet again, the closing company and the buyer and the seller might not get this thing signed immediately, and the commission understands that. So who are the parties to this thing? You might get a test question around that. Well, the parties to the closing instructions are the buyer, the seller, and the closing company. The agent is not a party to the closing instructions. Now, I do want you guys to know this. The agent does hire the closing company. The agent does hire the closing company, but yet they're not for this purpose. They're being hired as what's called a scrivener. The scrivener, they are getting paid to put together the paperwork, maybe the deed, the different things for the agent, because that's the agent's responsibility. So the agent hires the title company as a scrivener. The buyer and the seller hire the closing company for the actual closing of the property. Let's talk about compensation real quick. So, firstly, we know we have to have a listing or buyer agreement in place. This is our employment agreement, the exclusive right. You must have an exclusive right in place to get paid, and you have to fulfill the terms of the agreement. Typically, what that is helping the buyer buy, helping the seller sell. Find the tenant the property to rent. Find the landlord a tenant. That's what this thing looks like. Performance. We perform and we get paid. Most of the time, that performance is closing the transaction. Now, here's the thing. You don't get paid most of the time if one of the clients backs out. Now, that would be through a contingency, right? So this is what I mean by this. You might say, well, hey, I found a ready, willing, and able buyer. Pay me. Well, inside the contract to buy and sell, right, between the buyer and the seller, they have these things called contingencies. Most of the contingencies are buyer contingencies, like inspection, right? Mr. and Mrs. Seller, I, the buyer, intend on buying your home contingent upon the inspection looking the way that I expect the inspection to look to my sole and subjective discretion. Mr. and Mrs. Seller, I intend on buying your home contingent upon the bank lending me money to terms that are acceptable to me, to my sole and subjective discretion as the buyer. All right. So if the buyer walks away from because of one of these contingencies, you do not get paid. Now, here's the other thing. If your client does walk away, let's say the seller walks away, right? We're like, it's the day of closing and it's runaway bride. The seller does not show up to the closing table. Well, I think at that point you have earned your commission. Now, as the seller's agent, you don't get to keep the buyer's earnest money. That earnest money is going to go back to the buyer. You do not get to keep that. What you would have to do is sue your client for your commission. That's how you would earn that. Now, your historical commission structure, and I did put historical in there intentionally. Paid by the seller from the proceeds of the sale. Remember, for the most part, every question that you're going to get is from the perspective of the sell side. Now, it's typically a percentage base, but yet we also see the split with a co-op. Now, if there is a split with a co-op, we'll talk about that. But we also know that you could be on a retainer. There could be an hourly fee, other success metrics that are in place. Guys, guess what? It's all negotiable. It's not set by the commission. You can set your pay up however you want, yet you do know that you cannot charge extra for preparing documents. That's a lawyer's job. So unless you're a lawyer, you cannot do this. And it says buyers may be paid directly by the seller and or the buyer. And it is going to be clearly outlined in the buyer agency agreement. The buyer agency agreement is going to read one of two different things. Buyer will pay their client or their agent, or buyer will pay their agent, yet they instruct their agent to try to get compensation from the seller. Those are the only two options. Buyer will pay, and please go see if you can get paid by the seller. They instruct them to. So when we're going through this in this employment agreement, because that's what both of these are, the agency agreements are both employment agreements. And if there is a change, if there is any change to the commission, it's in a written agreement. And that written agreement would be an amendment. It would be an amendment with broker. It would be an amend extend with broker. All right. That's how it would be lined out. Anytime that there's a change in your agency agreement, and we understand that the agency agreement also talks about compensation. So if there's any changes whatsoever to the agreement that I have in my employment agreement with my client, we must amend it. And this would be an amend with broker. Now your fee sharing, guys, what they're going to call this out in your exam. It's going to be called a co-broker or a co-op. The co-broker or the co-op will always be the buyer's agent. Always, 100% of the time, the co-op will never be the seller's agent. Never, ever, ever. It will always be the buyer's agent. So when we're looking at this thing, you will come from the perspective of the buyer on this one. Again, commissions are always negotiable. They must always be written to be enforceable, which we understand. No written contract, no legal claim. Now, I said, let's give these guys like the one pager of all this thing. And as I was looking at this, I said, if I just wanted one document to go look back on that I should probably just screenshot while I have the opportunity, this would be it. My brokerage relationships. Transaction broker in Colorado is your default unless you have written agency. Dual agency is illegal, so you have to do a change of status form. Your client must consent to exclusive contracts. When we're talking about your listing and your buyer agency agreement, they must be in writing in Colorado for agency. They have to have a definite end date. You must use commission-approved forms. Your compensation is established in your employment agreement. It's for performance. And you got to get the deal to close, right? Unless the client fails to perform. So compensation is negotiable and it must be in writing. Splits, right, to the co-op are required seller consent. The seller must tell you, their agent, hey, agent, yes, you can offer a percentage or a split of your compensation to entice a buyer's agent to bring a buyer. Forms and closing, commission approved forms. Closing instructions should be started at the listing and signed at the time of contract. The contract to buy and sell between the buyer and the seller. Brokers, you have to account for all funds in a trust account. Conway-Bogue, that's where this whole thing started. And because of Conway-Bogue, you have the right to practice limited law in transactions that you are associated with. You can't give legal advice because you're not a lawyer. And you must treat the others fairly, the customers. Anyone else's customer or your customer, you must treat them fairly and document everything. So know the difference between a client and a customer, because that's going to show up for fiduciary and what you owe them. You need to understand what the employment versus just cooperation may look like, right? Where we have the co-op broker versus when we're being employed. And keep in mind, if it's not written, it really didn't happen because now it's unenforceable.